All rise. The Honorable, the Chief Justice, and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Dean Manning will now give a few welcoming remarks for us.
Thank you, Mr. August. Welcome to the Ames final round. I have some special thanks to give and just a few words to say about this great event. For more than a century, the Ames Moot Court Competition has been a wonderful tradition at HLS. It was established in honor of the late Dean James Barr Ames, who took great interest in the work of the law clubs formed by students for the argument of moot cases. Winning teams in the past have included names you might know, people like Harry Blackman, Nico Bowie, Henry Friendly, Sheila Kuehl, Deval Patrick, Barbara Jacobs Rothstein, Cass Sunstein, Kathleen Sullivan, and Guhan Subramanian. So our moot court has kind of a cool history. Making the final round is a very big deal and a very big accomplishment. And what we're all about to witness will be one of the highlights of our academic year. It's also enormously engaging and fun to watch. Chief Justice Roberts once said about oral argument, quote, "It's all in the dynamics. It's all in the spacing, in the tone. You need to find a way to look comfortable. The justices can sense fear. They're ready to pounce." And Kathleen Sullivan, the best oralist in the 1980 Ames finals, likened oral argument to jazz. "Be prepared to improvise," she said. Tonight, for the first time, and I hope also the last time in the history of our competition, we're holding the Ames final round not in person, but virtually. I'll soon thank the student advocates, the BSAs, the staff, and the judges who've made tonight possible. But I want to acknowledge here the extraordinary things our two Ames final round teams have done to get here. It was 1 year ago today that we had the second semifinal argument in the Ames courtroom, just after public health measures had required us to limit attendance and begin social distancing. That in itself was disappointing. And I know it's disappointing not to be here in person today. And so I want to take this moment to recognize that as extraordinary as these Ames teams are every year, these two teams deserve special recognition. The dozen students competing tonight are here because of strong effort, long hours, disciplined writing, refining again and again, real teamwork, and lots of moot courts for the moot court. This is all a quintessentially collaborative, team-based effort, and it's a huge challenge and a major accomplishment even in normal times. To do all of this in the pandemic while learning and working remotely is truly extraordinary. I'm proud of and grateful for the resilience and character of these teams, which have done their good work in the face of adversity and have done so with grit and equanimity. I also want to acknowledge our terrific bench. What I love about the Ames competition year in and year out is that our judges treat this like a real oral argument. They ask good and hard questions, and they seem genuinely intent on figuring out the answers to the complex issues that our case writers have written. We are grateful that these three superb judges have agreed to serve and to hear argument remotely. And we're honored to have three exceptional members of the bench sitting on the Court of Ames this evening. The Honorable Stephen G. Breyer, the Honorable Judith W. Rogers, the Honorable Mariano-Florentino Cuéllar, and I'll say just a few words about each. Justice Breyer took his seat as an Associate Justice on the Supreme Court in 1994. He received an AB from Stanford University, a BA from Magdalen College, Oxford, and in 1964, an LLB from Harvard Law School. I also get to introduce one of his classmates in just a moment. Justice Breyer served as a law clerk to Justice Arthur Goldberg. He then went on to serve as assistant to the Assistant U.S. Attorney General for Antitrust, as Assistant Special Prosecutor for the Watergate Special Prosecution Force, as Special Counsel to the Senate Judiciary Committee, and later as the committee's Chief Counsel. Justice Breyer also served as a member of our faculty for nearly 30 years, and in 1980 he began his service as a judge and ultimately as Chief Judge on the U.S. Court of Appeals for the First Circuit. During that period, Justice Breyer also served as chair of the U.S. Sentencing Commission. I know that all of you at home will join me in thanking and welcoming Justice Breyer back to HLS. Judge Rogers was appointed to the U.S. Court of Appeals for the D.C. Circuit in 1994. She graduated from Radcliffe College in 1961 and Harvard Law School in 1964, and she earned a Master of Laws degree from the University of Virginia School of Law in 1988. After graduating from HLS, Judge Rogers served as law clerk at the Juvenile Court of the District of Columbia and then went on to work as an AUSA in the District of Columbia, as a staff attorney at the San Francisco Neighborhood Legal Assistance Foundation, and as an attorney in the criminal division at the U.S. Department of Justice. After serving as general counsel to the Congressional Commission on the Organization of the District of Columbia, Judge Rogers worked for the mayor of the district on congressional and local legislation before becoming the Corporation Counsel for the District of Columbia in 1979. In 1983, she was appointed to the D.C. Court of Appeals and became Chief Judge in 1988. President Clinton appointed her to the D.C. Circuit in 1993. Please join me in thanking Judge Rogers and in welcoming her back to HLS. Justice Cuéllar began serving on California's highest court in 2015. He graduated from Harvard College in 1993 and Yale Law School in 1997 before earning a PhD in political science from Stanford in 2000. He began his legal career at the U.S. Treasury Department and clerked for Chief Judge Mary Schroeder on the U.S. Court of Appeals for the Ninth Circuit. Justice Cuéllar joined the Stanford Law School faculty in 2011, where he was ultimately appointed the Stanley Morrison Professor of Law and Director of the Freeman Spogli Institute for International Studies. During his time at Stanford, Justice Cuéllar also served on the White House Domestic Policy Council and is co-chair of the National Equity and Excellence Commission. He currently serves as a member of the Harvard Corporation, this university's highest governing body, and serves on the boards of the Hewlett Foundation and the American Law Institute, and chairs the boards of the Center for Advanced Study in the Behavioral Sciences, AI Now, and Stanford Seed. Please join me in welcoming Justice Cuéllar. Thanking him for being on our panel. It's tremendously generous of all three of you to take times out of your demanding schedules to prepare for argument and to be with us today. We are deeply grateful. So again, my thanks to all three of you. Okay, now we are in the home stretch. We are going to introduce the teams and thank the staff and students who made tonight possible. Now the teams have selected their own team names. Descriptions of those names can be found in the Ames program. So we're starting with the petitioners, the Justice Robert H. Jackson Memorial Team. Matthew Arons, oralist. Max Bloom. Taylor Custer, oralist. Dustin Fire. Colleen O'Gorman, and Sam Stratton. I know all of you watching are joining me in giving the Robert H. Jackson Memorial Team a big round of applause. And now the respondents, the Lloyd Gaines Memorial Team. Jason Bell, oralist. Ameze Belo-Osagie. Lauren Bilow. Davis Campbell. Travis Fife, and Michael Torcello. Again, please join me in giving the Lloyd Gaines Memorial Team a large round of applause. This event could not have happened without the remarkable work of students and staff, and I thank each one of you for your extraordinary work. So the Vice President for Ames, our bailiff this evening, John August, The upper level Ames Committee, Tyler Underwood, the chair, Kareem Carroll, Julia Keller, and J.V. Langkild. President of the BSA, Alexis Alvarez, and a number of HLS staff, James Brito White, Catherine Cronin, Steve Foote, Linda Grant, Liberty Keneally, Courtney Majoka, Matilda Matovu, Jeff McNaught, Richard Smith, Yvonne Smith, Jessica Soban, and Ben Watson. The record for today's case was written by Tajinder Singh, Best Oralist in 2007. We deeply appreciate his hard work and legal ingenuity. And I hope you will all join me in giving our staff and students a very, very big round of applause for all the tremendous work they did to make today's argument possible. And with that, I have subsided. We will begin, and I wish best of luck to both teams. Thank you.
All right, we'll now hear the case of Laura Tanner versus the state of Ames. Tanner, your lawyer, counsel.
Mr. Chief Justice, and may it please the court. My name is Matthew Arons. On behalf of the petitioner, Laura Tanner, I will address the First Amendment issue, and my co-counsel, Mr. Custer, will address the Fifth Amendment issue. We'd like to reserve 3 minutes for rebuttal. Ames can seek to protect its citizens from the harms of non-consensual pornography, but it cannot set aside the First Amendment to do so. And the NCPA violates the First Amendment for 3 reasons. First, the NCPA bans speech protected by the First Amendment. The few exceptions to the First Amendment are defined by tradition, but there's no tradition of criminalizing the sort of speech at issue here. Second, the NCPA is subject to and fails strict scrutiny. Most notably, the NCPA's cramped public interest exception and negligence mens rea standard are at odds with this court's precedents and First Amendment values. Third, the NCPA is...
This doesn't affect your time, but it's very hard to see you. You're a tiny little figure on this screen. Is there any way it can be made bigger? I mean, it'll do if it's like this, but if it can't be made bigger, but if it could be made bigger, it would be helpful. And I don't know if the technical people can do that.
I will defer to the technical
people. I hear you very well. I hear you very well, and I see your smiling face, but I do not see you very well. Why can't we just make that corner over there, the whole screen? Ah, there we are. Okay, pick it up, please.
Well, let me say that may be working for Justice Breyer,
but it's not
you remain a small box for me. I don't know about Justice Cuéllar.
I'm fine.
All right. So let's go ahead.
Oh, third. I didn't make it smaller for you.
No.
No.
No change whatsoever.
Okay.
Third,
go ahead.
The NCPA is facially unconstitutional because of its striking overbreath. The NCPA would criminalize the publication of images from Abu Ghraib and speech like the speech in this case that shines light on sexual harassment. A statute that chills speech on this scale is incompatible with the First Amendment.
Counsel, your argument has a lot of moving parts, but let me just focus on a piece that seems foundational. How important to our analysis is the social value of non-consensual pornography as a category of speech? And if it is important in our analysis, then what is the value of non-consensual pornography to society?
2 responses, Your Honor. The first is that it's not particularly important to the analysis. So this court said in Stevens that much of what we say to one another lacks serious value. In general, outside of carefully prescribed categories, we don't inquire into whether or not speech does or doesn't have value before applying the First Amendment. And the second response is that despite the state's claim that much of what's regulated by the NCPA doesn't have serious value, that's at odds with the text and the reality of the statute. So if you take the statute's public interest exception, it says that speech in the public interest can only be made to small audiences. By its very terms, the NCPA acknowledges that there's material in the public interest that it is criminalizing the publication or distribution of So that's very different than the sort of ordinary run-of-the-mill non-consensual pornography case that you might have in mind with designing a statute like this one. And strict scrutiny would apply here. Strict scrutiny would apply here under this court's precedent first in Reed. In Reed, the court said that the crucial first step in First Amendment analysis is determining whether a statute makes content-based distinctions on its face. The NCPA does so. It restricts images based on whether it shows intimate parts or sexual acts. Once strict scrutiny applies.
The Exchange Commission has lots of rules that affect what you can say and what you cannot say in a prospectus. Is that content-based?
I'm sorry, Your Honor, it was slightly difficult to hear you. Would you mind repeating the question?
The regulatory agencies, the SEC, power regulation, electricity, FERC, lots of, you just look through the US code. It's filled with regulations, if not statutes, which say what you can say specifically if you're a regulated company or involved in this area and what you can't say. I just wonder, is that all content regulation and we're supposed to just use strict scrutiny, or how does that work?
No, Your Honor, two responses. The first is that many of those regulations fall into other exceptions to the First Amendment. They might be characterized as commercial speech. They might be speech integral to criminal conduct, but there are other ways of getting at some of that regulation. And the second response is to point to some guideposts inside this court's First Amendment jurisprudence to determine what's content-based. Admittedly, this court has in the past struggled to define content-based versus content-neutral regulations. But this
exactly,
case,
and I just want to know what your definition is and how it works and why, that's all. Sure. I grant you that many courts, including ours, in my opinion, have failed to do that. So I would like to know, you've thought about it. What's your opinion?
Two guideposts, Your Honor. The first is the bright line rule this court laid out in Reed, which is when a statute makes facial distinctions between different kinds of content, but you don't need to adopt Reed's rule, which you might be skeptical of, in order to come to the conclusion in this case. For example, courts have also paid attention to whether a content-based regulation has the purpose or the effect of impairing public debate or impairing speech. This statute does both of those two things. So for example, on Joint Appendix page 22, there's reproduced the message board post that accompanied this image, and it criticized a corporate culture of blatant sexual harassment. That's exactly the sort of speech that should be constitutionally affected. And this statute has the effect of criminalizing that. The third guidepost we'd point to in content-based versus content-neutral regulation is what the state's motivations are. And that's playing off this court's secondary effects jurisprudence. But here, the state has very clearly targeted the primary effects of speech. They're concerned with the emotive impacts of this sort of content. Now, there may be a compelling interest in trying to regulate that with the least restrictive means possible, but it's certainly the exact sort of content-based regulation that, regardless of where on the spectrum of content-based tests we fall, should be regulated.
We'll come back to this, counsel, but because you went right into strict scrutiny, we didn't maybe spend quite enough time just exploring this question of what exceptions might apply to the full coverage of the First Amendment. And Justice Breyer was getting at this when he was asking you about the way the SEC or another regulatory agency engages in the regulation of speech, in effect. So you surely wouldn't consider this kind of material obscene. I understand that from your briefing. But is there no exception that might apply short of one that would only fit if every kind of speech act that would come under this statute was obscene? In other words, what if it's awfully close to obscenity? Isn't there something that the state could do here that might qualify as meriting regulation when it's much more than just some sort of anodyne statement about the corporate profits of an entity or something is unlikely to offend us at?
Two responses, Your Honor. Even if you were to extend the category of obscenity slightly, what the state is asking for here isn't a small extension. And the easiest place to see that is to start and stop with Miller Prong 3. Miller Prong 3 says there has to be an exception for works of serious value. The small audience limitation on the public interest exception here doesn't do that. So it wouldn't be a small modification of obscenity to allow the NCPA. It would be a rather large one. The second point, though, is in terms of how this court defines new categories of speech. In general, we look for tradition narrowly defined. So Alvarez is a good example, where this court didn't say that we could criminalize lying about the Medal of Honor simply because defamation or other categories of false speech had been regulated in the past. We looked for a narrow and specific tradition that would cover this kind of speech.
And I get, counsel, that argument would be one that would really push back on the state's argument, presumably that some sort of broad privacy protection exception applies. So even if I grant you that, though, presumably your argument is not that the state is unable to regulate obscenity. You're not asking us to leave that aside. So I guess, would your argument be that none of the conduct that is regulated by this statute involves obscenity, or that even if some proportion of it does, the fact that not all of it falls under obscenity means that that exception doesn't apply?
The argument is that relatively little of it falls into obscenity. So you could imagine an image that was shared that would also be obscene under the Miller test, but that in all likelihood is a vanishingly small percentage of this sort of material. And the other problem here is, just to return to Miller prong 3, there needs to be an exception for works of serious value. This court has emphasized that as a cornerstone of the First Amendment, and that exception isn't here. I think that alone is enough to doom this under the Miller test. So the other problems under Miller are kind of twofold. We need to appeal to the prurient interest. It would also need to be patently offensive. For something to be patently offensive, for example, it would have to show hardcore sexual conduct. But most of the images here don't do that, so they wouldn't fall under the Miller test as traditionally defined. Instead, it would be a substantial expansion of Miller, and that's at odds with this court's treatment of exceptions.
I don't want to interrupt Justice Rogers if she was going to say something. Wait.
Go ahead. If you want to follow up on that point, I was going to move to slightly something different.
All right. Go ahead. Sorry.
As I understand, though, counsel, your basic argument here is that even if some of the points that are being raised by Justice Cuéllar's questions, it is the aspect of public interest that needs to be protected here. So even if there are all of these other problems, there has to be some scope for speech where there is an aspect of public interest, even though the conduct is otherwise private. So one of the concerns is, can't any type of speech be manipulated, as it were, into an argument that, well, there is a public interest here? In other words, does your argument reach too broadly?
Your Honor, there's a risk in deciding what is and isn't the public interest, but this court's precedent is comfortable with that risk. So in Florida Star, the court said that a newspaper had the right to publish the name of a rape victim. In Bartnicki, the court said that a radio station could publish a wiretapped conversation between a union leader and a union official or union negotiator. And the reason is that core to the First Amendment is this idea that speech on matters of public interest has to be protected. And as those precedents show, even
here the statute, isn't it, counsel, is just limiting the images. It's not limiting the verbal description of what is depicted. And that's what the legislature apparently was most concerned about, the harm associated with transmitting the image.
2 points on that, if I may, Your Honor. The first is that words are not a substitute that this court's precedent would accept. So if the jacket in Cohen v. California said, "I disapprove of the draft," instead of the expletive that it actually used, the difference in that form of the message, or only allowing the toned down message, would have been an unconstitutional limitation on speech. And the same goes here, forcing individuals to say, describe sexual assault, instead of vividly illustrating what happened in the workplace, what happened at Abu Ghraib, or what happened with Anthony Weiner is very different. The second point, is
that brings the question of what is the speech here? In your opinion, what's the speech?
The speech here is the sharing of the video that MS sent to whoever received it and posted it.
So in other words, you're saying that if, in fact, person X gets a picture of a naked man or a woman, which is totally private, they can send it to anybody in the world just for fun. I mean, they get a picture, they send it everywhere, just for fun, and the lives of those people, since it's quite a graphic image, are ruined. Is that right?
No, Your Honor. No, Your Honor, our point is that statutes that go to that very real social problem have to satisfy strict scrutiny. So that is a real social problem.
I just tell you, I don't know what test it satisfies, but you put any test in you want. I wanted to know if that was your position, that your view, that's what I said. Is that right or not right?
It's not, Your Honor. Our position is that
if it's not
could
right,
draft.
then what's the line? Why isn't it?
3 lines that we propose. The first is that you would need to fix the small audience problem and allow disclosures in the public interest. The second is that you would have to eliminate negligence mens rea in the statute.
Oh, you are attacking the statute as a whole.
That's correct, Your Honor.
The audience doesn't have much to do with this, I don't think, but assume it doesn't. Has nothing to do with this case. Are you attacking the statute on its face? I mean, or are you just saying they can't use it here?
2 responses. First, small audience does have much to do with this case because it was posted on a message board to 183 people. The reason the small audience or the
apparently the state thinks that the small audience does not get them off. So I'm not sure what the relevance of that is, but I really want an answer to my question. And my question is, fine, quickly, I hope, you'll be able to tell me why, in your opinion, your interpretation does not mean that the most intimate and private activities of every individual can, if someone gets a hold of a picture, be spread for the world to see. The reason I said privacy is the most important thing. Well, what do you think? I want your view.
Your Honor, we concede there is a compelling state interest, and we believe that the state could draft a more narrowly tailored statute that would pass constitutional muster. For example, the statute that the Vermont court upheld in Van Buren, one of the few state Supreme Court cases, had the 3 elements that we call for. It eliminated the small audience issue. It used a level of mens rea above negligence. It imposed an intent to harm or profit requirement. So this is a problem, a real social problem we concede, and one that states can deal with without allowing all of these images to be made publicly available. But the state didn't do so here. Instead, what Ames did is pass a statute broader than any of the 46 others that states in the union have already adopted. It's that overbroad, poorly tailored statute that's problematic, not any attempt to deal with this social problem.
And to follow up on Justice Breyer, I wonder if at core your argument is that the state just acted too quickly, or if you have a more fundamental problem. In other words, would you be making the same argument if the state had said, look, we tried a civil remedy, as you suggest in your briefing. We tried to have people just rely on tort law. We tried to just tell people it's a really, really bad thing to do this, just using the bully pulpit. None of that worked, so we need a criminal statute. We tried one with a broader public interest exception, but that kind of went rampant because if you disclose to a large group, then you can't really control who posts to who posts to who posts to, then it gets on Facebook. So now we have this statute. Would you then be like, okay, that's fine? Or is it likely you'd still be saying, no, fundamentally, there's something core about the First Amendment. And if we're going to be in awe of it, it doesn't matter how much the state has tried, it's not going to be able to promulgate a criminal statute like this.
I see that I'm just about out of time, but if I may answer the question.
You may.
That would certainly strengthen the state's case, but we don't need to go that far here. I think a simple comparison with the many other state statutes that use less restrictive means show that Ames went too far too quickly, and we don't need a long history of Ames trying other things to show that this is what's necessary or not. We could point to the example of 46 other states that have adopted less restrictive statutes. For those reasons, we urge this court to reverse the decision below. Thank you.
Thank you, counsel.
Thank you, Mr. Chief Justice, and may it please the court. The Fifth Amendment guarantees that no person shall be compelled in any criminal case to be a witness.
Right person. There we go. Thank you. Thank you. Go ahead.
Sorry, Mr. Chief Justice. The Fifth Amendment guarantees that no person shall be compelled in any criminal case to be a witness against themselves. But the compulsion order here violates that right for at least 3 reasons. First, Ms. Tanner must say the passwords. She must disclose the content of them. And that's explicit testimony that's protected under the Fifth Amendment. Requiring her to say it forces her to be a witness against herself. Second, disclosing the password is effectively the same as turning over the documents that those passwords encrypt. And this court has never extended the foregone conclusion exception to strip the implicit testimony embedded in that act of its protected status, and it shouldn't do so here. So the implicit testimony is protected as well. Third, even if the court were to extend the foregone conclusion exception to the facts here, the state hasn't met the high bar that exception puts forward. And as a result, it wouldn't be met here and wouldn't strip implicit testimony of its protection.
Which we may get to, counsel, but you do have in your briefing, and now you've restated it in your opening, almost like a secret ambition, if I could put it that way, which is to get us to upend Castigar and a whole framework of essentially how it is that the government seeks and obtains documentary evidence. So I just wonder how far you want to push that argument, and is it absolutely essential to your effectively representing your client and getting relief here?
Yes, Your Honor. There are a number of ways the court could resolve this case. And we think the most straightforward one would simply be to say that when Ms. Tanner is forced to say, my password is X and the contents of the password, that's compelled, incriminating, and testimonial under this court's case law from Castigar and from Fisher. So that's the most straightforward way to resolve the case, Your Honor. But in addition to that, we think that the act of production associated with disclosing the password, that when you disclose the password, you also turn over all the documents that password encrypts, there's implicit testimony there as well. The foregone conclusion exception is the only way to strip implicit testimony of its protected status. And that shouldn't be applied here because Fisher and the cases since have only applied the exception in the context of business and financial records, which aren't at issue here. Even if the court did extend the foregone conclusion exception, though, the state hasn't shown that the implicit testimony embedded in the act of production is a foregone conclusion to the state. It would have to show that the existence, possession, and authenticity of these documents were known, as the state concedes, as a truism or effectively self-evident. And that's not the case here before the actual compulsion order issue.
So let me ask you in terms of how you're approaching this case. And since you're in the Supreme Court, you have some leeway, it seems to me, in your argument. Are you looking at the privilege as the court had looked at it for years in terms of protecting an area of privacy? Or are you looking at it more in terms of, are you looking at it as how to facilitate law enforcement now that we're in this age where everybody has everything on their iPhone or personal computer and they are blocked by passwords, when the state has already obtained a search warrant for these two devices? And in that sense, why does the password involve any incriminating testimony for your client?
Yes, Your Honor. The key here is that the Fifth Amendment guarantees that a person's not going to be put into what was called the cruel trilemma, whereas they tell the truth, they'll incriminate themselves. If they lie, they'll commit perjury. And if they're silent, they'll be held in contempt. When a person's put in that situation, the Fifth Amendment extends the invitation of silence to remove that problematic position for that person.
I think the question was, if I understood it, excuse me, Judge Rogers, but I had the same question. How does handing over the password incriminate your client?
Yes,
I don't think either of us said whether it's a cruel trilemma or not. We want to know, how does it incriminate your client?
It does so in the following way, Your Honor. As soon as Ms. Tanner says her password, it's going to open up the devices here And she reasonably believes, or it's her belief, that that will lead the government to incriminating evidence that the government will use to try to put her
Is there
in
any
jail.
evidence of that in this case? I mean, they have a search warrant for all the evidence they're going to get out of that. If they go beyond the search warrant, then I guess they're liable. They can't do it. And as far as the search warrant is concerned, that evidence they're entitled to.
They're certainly entitled to the evidence, Your Honor. But our position is that they have to get at that evidence in a way that's consistent with the Fifth Amendment.
I have all the evidence in my house, 10,000 pounds of cocaine. And where it is it's in the basement. And by the way, I have the basement totally locked and I have the key. And the police have a search warrant to go look for the cocaine in the basement. Do I have to give them the key? There is no other way to get that cocaine because it's going to self-destruct in 6 hours, which is the time it will take them to break in another way. Do I have to give them the key or not?
Under Fisher, Your Honor, you would have to give them the key so long
If I
as
have
they
to give them the key, what's the difference between having to give them the key and having to give them the password?
You'd have to give them the key, Your Honor, if the implicit testimony bound up with giving them the key was a foregone conclusion to the government. So if the government knew that the cocaine existed, that you possess the cocaine and that it's actually there, then you would then that would
That's how they got the warrant. That's how they got the warrant. The exact same way that here they got the warrant to go and get the papers that are locked up in the computer.
There are two differences here. So there are two differences here I'd like to point out, Your Honor. First, when you hand over the key in your hypothetical, you don't actually say anything explicitly. That's different than the case where you say your password. It's actually testimony.
I see. I have a great idea for every drug runner in this country. Instead of locking up your cocaine with a key, you lock it up with some word that you have to say, ishkabibble, all right? Now, it all opens with ishkabibble and it doesn't without it. Now we have a different case?
Yes, under the Fifth Amendment, you do have a different case, Your Honor, because there you're forcing the suspect to reveal the contents of their mind and effectively using that in the prosecution against them. And that's explicitly what the Fifth Amendment is meant to protect against. And so
Perhaps,
that's an important...
but you know, this is a difficult argument, counsel, so I grant you that. And I do think you are trying to make sure we don't fail to recognize the extent to which our doctrine does protect people from being forced to divulge information that is going to put them criminally at risk. We have a framework for dealing with that. Of course, we have warrants and so on. But I guess, in a way, going back to the original question I was posing for you, what is the government to do in a like? Just let me like channel Justice Breyer for a moment and give you another hypothetical, which is imagine a world where like all documentary evidence of any kind is now password protected. Why? Because that's like good cybersecurity practice. It's what we're all being pushed to do. And maybe 5 to 7 years in the future, just as we've sort of figured out what's necessary for social distancing in the midst of the pandemic, we all like hyper password protect. It's totally hyper encrypted. Now, when the government, provides you with a subpoena for your documents, if you don't serve up the password, you're effectively neutralizing any capacity the government has to understand whether those documents say what they need to verify. And I just wonder if your position ultimately is about laying the foundation to make such subpoenas or warrants essentially irrelevant, because if they're all password protected and no one has a responsibility to serve a password, then the government never gets the information.
So I'd like to make a few points there, Your Honor. First, we'd say that there are other ways, even in that world, if we grant that it's technologically possible that only the person who knows the password can get access to it, and we would push back that that's not a technological reality today. Even Professor Kerr, in his article on encryption workarounds, suggests other ways of exploiting encryption schemes. There are other ways that the government could get access to documents there. Someone else might know the password. For example, it's possible.
Maybe, counsel, I hear that point, but if we get all quantum computing on each other and just like imagine that this is completely secure,
sure.
What is your position?
So our position there would be that there is a legislative solution the state could take, which would say that they could have the producer of devices or folks who create the software that encrypts it have a different means of getting access to it, provided that the government satisfy the Fourth Amendment standard. That would be a way to square both interests here. The government would be able to execute its search warrant, and it would be able to do it in a way that doesn't force the suspect to effectively participate in their own criminal prosecution. And that's an important point to make, because it's a guarantee under the Fifth Amendment that you don't have to be a witness against yourself. So that would be a way that the state could respect both constitutional rights that defendants have. And so
that's one way of looking at the world. But of course, and that's one of the arguments the state makes, and unless it gets the password from your client, the state will resort to much more intrusive means, and therefore passwords will mean nothing if you become a suspect for a criminal prosecution. And there are, I agree with you, many ways that the government can build its case without getting access to her phone and documents. But as a practical reality, we know that's not what's happening. And so the question in my mind is whether the type of concerns that the Fifth Amendment was addressing are such, as recognized previously in our cases, that where we're talking about my personal iPhone, my personal computer, and we're not talking about any concern about national security. At most, we're talking about obscenity, light. What role does the privilege have to play in modern society? Or because we're in a computer age, do we just adapt these protections? And they essentially, in your argument and view, amount to nothing.
Your Honor, the importance of the privilege today is the same that it's been throughout American history, which is to make sure.
But the argument, though, counsel, as you know, and I'm sorry to interrupt, is that, the common law, the privilege was very different. And that's what we were talking about in terms of, is giving the password incriminating to your client? And it's not the same as handing over whatever file is potentially incriminating here.
Yes, Your Honor. So the state makes an argument about the original meaning of the word incriminating that Professor Kerr has recently put forward. But Professor Kerr concedes that under Castigar, it would be incriminating because Castigar said merely causal. But to get to your more fundamental point, Your Honor, if we want to go back to what the Fifth Amendment meant at the founding, at the original meaning, we should look to what the founding generation understood the word witness to mean. And their justices of this court have recognized that Fisher's interpretation of the word witness as basically limited to testimony was very likely a narrowing of what the common law privilege was understood at the founding. It would have included testimony as well as evidence. So to go back that far would suggest another way to resolve this case, which would grant even more protection to criminal defendants than currently is the case under the existing standard from Fisher. But ultimately, the Fifth Amendment is supposed to be about a protection for the way that the government's not allowed to force people who are presumed innocent until proven guilty to participate in the process of stripping them of their liberty. And so
would your argument be the same, just picking up on your point about just how much this pivots for you on the original understanding of the Fifth Amendment? If we vary the situation slightly, and instead of the government seeking to compel your client to produce the password by speaking it, we have a situation where the government knows that the password, being very complicated, has been written down by your client, and the government is seeking that piece of documentary evidence where the password is written down.
Yes, Your Honor. We would argue that the state couldn't compel the witness, the Ms. Tanner, to hand over an evidence in that scenario because the password, we would argue, is a private document there. And Fisher and the cases that follow, Doe 1, Doe 2, the foregone conclusion exception has only ever been extended to strip implicit testimony of its protected status in the context of financial and business documents. The court made clear in Fisher, for example, that something like a personal diary would raise very different concerns and reserve the question as to whether or not the foregone conclusion exception would apply in such a context. And we'd argue there's nothing more private than a person's password, and that many people, I think, would be very surprised to think, as the state seems to believe, that passwords essentially don't matter right now, that the government can always get by them by compelling you to say that to the government, or in your hypothetical, to hand over a piece of paper. So we would argue that the foregone conclusion exception couldn't be extended there, and as a result, the compulsion order would still be invalid. And for all these reasons, we'd ask you to reverse the decision below.
Counsel for the state of Ames. So they're having.
Thank you, Mr. Chief Justice, and may it please the court. The non-consensual dissemination of someone else's sexually explicit materials is a devastating and growing problem.
For a second, because we're not getting you on the screen. We're getting the last counsel on the. Oh, there you are. Okay, thank you.
Are we okay, Justice Breyer?
Yeah, fine.
Great. It is a devastating and devastating problem that has affected over 10 million Americans. Victims report losing their job and suffering profound mental health consequences as a result of non-consensual dissemination. That is why the state of Ames joined with 48 other jurisdictions across the country to criminalize this conduct. History, tradition, and this court's precedent all support the constitutionality of the NCPA. This court should therefore affirm for three independent reasons. First, none of the speech prescribed by the statute is protected by the First Amendment. Second, even if the speech receives some constitutional protection, it survives any level of constitutional scrutiny. And third, severability is sufficient to save the statute's constitutionality should this court have any concerns about the precise statutory language. First, none of the speech prescribed by the statute is protected by the First Amendment. Most specifically, this court should recognize a new categorical exception for non-consensual pornography to the First Amendment's coverage. For both.
Counsel, before we get to your proposed privacy exception, let's just take a step back for a moment. I gather that the spirit of your argument is something like, look, this is a really serious problem. It's not the state's first choice to do this, but it has to do something. And this statute, though it may seem burdensome to some folks and they may have First Amendment concerns, at the end of the day, the First Amendment does not prevent the state from doing this, and the statute does not go too far. If that's kind of the spirit of your argument, say a little more about what would it mean to you for the statute to go too far? In other words, fill in the blank of, if this statute had provided blank, then it would have gone too far. You with me?
I think so, Your Honor. And I think if you look at the different statutory provisions that ensure it's only limited to the most serious invasions of privacy. So, for example, the statute includes a reasonable expectation of privacy provision that ensures that it's not enough just that someone sent a sexually explicit photo to someone else and then was surprised when it was disseminated afterwards. Their expectation of privacy must be objectively reasonable. Similarly, contrary to Petitioner's suggestion that the mens rea requirement is negligence, the statute actually contains a three-part mens rea requirement that dissemination must be intentional. The person must know or should have a reason to know that the person didn't consent to disclosure, and similarly should have a reason to know that the image was private. So as that pertains to your question, is that I think if some of those elements were lacking, then that would be unconstitutional statute, both because it's not narrowly tailored and would incidentally affect speech protected by the First Amendment. And an example of that would be Indiana's statute, for example, that has strict liability with regards to non-consensual dissemination. And the only mens rea requirement at all is that, the person didn't know or knew that the person didn't consent. And so where you would have the incidents of accidental disclosures or strict liability, even for non-consensual distribution, that would be the type of statute that would run afoul of the First Amendment. But here, both history and basic First Amendment principles support a categorical exception for non-consensual pornography. The history that we outlined starts with Joseph's story in 1836, describing the way that freedom.
Aside for a second, I think that one of the arguments your opposing counsel made is simply this. I'll tell you what the speech is here. The speech is their client received what we normally consider a pretty obscene picture, and she didn't want it. And so she sent it to about, it's a big company. There are 5,000 people in this company and 1,000 executives. And she sent it to the executives and she said, look at this, my friends. Look what goes on here. Are you going to do something about this or not? Now, I would call that a political message, a policy message. And I don't see anything in this statute that says it isn't a crime. Maybe disclosure is made to a small audience to advance the public interest. It isn't a small audience. I don't know exactly what the public interest is, and that's pretty vague in a First Amendment area. So they say, of course, this is unconstitutional. You understand my message? I need to illustrate the point. That's what I did. And they want to put me in jail. What's going on?
Your Honor, first a factual clarification. The petitioner didn't just disclose it to her 182 coworkers. The message board that she put it on is publicly available. And if you look at page 18 and 19 of the joint appendix,
she wants the public to see it. She wants them to see it. She wants them to see it because she wants them to know the kind of place this is. And she says, I think those in charge should make it a different kind of place. Now, that is a message. That message is designed to change the world that she's in. So it's hard to think of something more at the core of the First Amendment. And it is hard to think how this statute doesn't put her in jail for doing it. At the very least, if she read it carefully, she'd hesitate to do it because it's vague. Okay? So what's the problem? Why does this not violate the First Amendment under the conditions I just told you?
Your Honor, the First Amendment does not straitjacket the state to be unable to respond to crucial social problems. It, in fact, strikes a balance between petitioner's need to express herself and the other social harms that this speech endangers. And I would point this court to its opinion in Burson v. Freeman, which involved election solicitation in front of campaign sites, which the court observed was traditional core political speech in the way Your Honor just described was happening in a traditional public forum, and the law was content-based. Despite those three core features of the statute at issue, the court said it nonetheless satisfied strict scrutiny because of the urgent need to ensure the sanctity of the state's elections. And similarly here, we think the statute at issue is narrowly tailored to a conceding compelling interest.
There's a perfectly easy alternative. The alternative is before you send this kind of message around to people, you be pretty goddamn careful who you're going to send it to.
Well, Your Honor, I don't think so. I think
the burden on the person sending it.
Your Honor, I think if you look at page 16 of our brief, we outline a variety of different mechanisms in which she could still send the same message that she wanted to. And as Your Honor suggested with opposing counsel, she could have just disclosed the same email she sent. She could have posted a redacted version of the video because the statute requires an identifiable person and identifies both their genitalia or a sexual act. And so and she could have went to law enforcement. So
I take your point. I take your point, counsel, and I'll acknowledge that the argument here is that there wasn't just a single way she could have gotten the message across. And of course, ignorance of the law is no defense. But if petitioner here had looked up the law, she would have found in section 545D2 a reference to a small audience. Now, as far as I know, the statute doesn't further define what a small audience is. What is a small audience?
Your Honor, a small audience is one in which the people receiving the message have abilities to ensure that it remains only before that audience. Here, as I explained at page 18 and 19 of the joint appendix, not only was this displayed to the entire internet, but MS's photo ended up on at least 2 different revenge pornography sites, which channel in exactly this type of perverse content. And so I think the question here becomes, why are those alternative mechanisms insufficient to achieve the message that petitioner wants to put forward when balanced against the devastating harm that this type of conduct has inflicted on many different people?
Assuming but go ahead, Justice Rogers, please.
So the state's burden here is reduced since it's just a showing of negligence, whereas many of the other statutes have a specific intent to harm. Now, the argument here, as Justice Breyer posed in your question, is yes, it may harm the individual, she says, but there's a bigger issue at stake. This is a large company. I'm trying to change the mores of the marketplace. And we see examples of that all the time in recent years. But here we're talking about criminal. This woman who arguably had a noble purpose in mind can be a criminal. And why was it necessary for the state to achieve its concern about the harm here to, what was it, MMG, to simply set a negligence standard? Could have put recklessly, could have been specific intent to harm, some further burden on the government before it can criminalize this kind of conduct, where it acknowledges in the statute that there is a type of public interest exception.
Well, Your Honor, I think that it's important to emphasize that the statute requires the dissemination be intentional in both negligence with regards to consent and privacy. But I take your point to be, why not an intent to harm requirement here? And I think the simple reason is that would render the statute under-inclusive, because many people post images without any intent to harm at all, whether it just be a joke, to humiliate, to just show a group of people who they think might be interested. And it's important to put this one case in the context of petitioner's overall facial challenge, which isn't just an argument that it was wrong to convict Ms. Tanner, but is rather an argument that this entire statutory scheme has to be shut down. And no side debates the fact that the empirical reality here is that this is, as the court below said, a bizarre set of circumstances. And the state is, sensitive to the fact that Ms. Tanner did had a noble intention. But I think the question has to become, is it worth subjecting MS to a lifelong of humiliation to achieve a message that, as I've explained, can be achieved through other mechanisms? And I think the court has to
let me just ask you, the focus of these statutes is revenge or to harm someone. And while I get your point about she is harming the supervisor here and his life is ruined, but we're talking about using the power of the state to criminalize conduct. That's what's of concern here. And while you interpret the statute to allow her to show this image to a friend, the statute could be read not to allow that, since it talks about transmittal. All right. So that's, doesn't the state have some obligation to look at what's been successful. I mean, I agree it doesn't have to examine everything as counsel for petitioner made and try everything itself. It can look at what's happening in the states and see how successful and unsuccessful they are. And if there had been some determination that only criminalization based on negligence is going to work here, then it seems to me you have a different scenario.
Of course, Your Honor. And there's a couple different parts there, and I want to make sure I respond to each one. So just on the looking at what other states and remedies might work, if you look at subsection A, 4 and 6 of the statute's preamble and purpose, the state made two crucial findings that respond to your question. The first is that this harm, or the harm of non-consensual pornography, occurs regardless of the intention of the disseminator. And then at subsection 6, that other alternative remedies are simply not working. And in fact, a third of the 48 non-consensual pornography statutes don't have an intent to harm requirement. And in fact, the Supreme Court of Minnesota in a case called State v. Casillas upheld the statute under strict scrutiny without an intent to harm requirement at all. And to your point about, this is going to revenge and harassment, I think that that's an unfortunate misnomer. If you look at the Sales and McGalvey article cited actually in Petitioner's brief, they outline the fact that in the vast majority of cases, the motive is as simple as wanting to make a joke or sharing it in a small community of people who know the person being disseminated against. And so while in the media, there are some pretty harrowing examples that are really leading the charge to motivate people to respond to this, sometimes the motive is as banal as just wanting to embarrass the person for a sick laugh. And so I don't think it would be enough for Ames or any other state to include an intent to harm requirement, because it would undermine the state's key purpose. And I want to broaden out a little bit to the fact that this is a facial challenge. And if you remember what Petitioner said here today, is that there are three problems with the statute. One, the intent to harm requirement, which we just discussed. Two, the small audience exception. And third, the negligence mens rea requirement. And severability is sufficient to deal with those last two, the small audience and the know or should have known language. And in particular, Petitioner's only response to this is that the statute says provisions are severable rather than individual words or something.
Counsel, if I may, I don't want to interrupt the flow of your argument, but just so I understand your point about negligence, when I hear the words know or should have known, the term negligence sort of just bubbles up in my brain. And I gather what you're saying is not, no, that's not negligence, but rather it would be wrong to assume that the entire mens rea of the statute is negligence. There are certain elements that are negligence-based, but if you look at the entire list of mens rea requirements, there's some more safeguards in there. That's what I'm sort of getting. Is that fair?
Yes, Your Honor. And so that is a correct description of our overall defense of the statute. And more specifically on severability, our suggestion is that you could render the knows or should have known language to just knows they didn't consent or knows it should have remained private. And I see my time is running out. And I would just say that is exactly the approach the court took to the obscene or indecent language in Reno. And therefore, this court can affirm on either ground.
Thank you, counsel. Please go ahead.
Mr. Chief Justice, and may it please the court. When the police have a warrant to search a cell phone or computer, the Constitution does not also require the owner's consent. But modern encryption technology is so powerful that it effectively requires the police to ask for a password to execute a warrant. Compelled password disclosure does nothing more than authorize a search and does not violate the Fifth Amendment privilege against self-incrimination. This conclusion follows from basic Fifth Amendment principles. A privileged communication must be both incriminating and testimonial. The password disclosure here is neither. First, the disclosure is not incriminating because it is not evidence and it does not form a link in the chain of evidence by virtue of authorizing a search. Second, the disclosure is not sufficiently testimonial to trigger the Fifth Amendment privilege because any information revealed by the disclosure is ancillary to the government's execution.
Wait. Let's just unpack that last statement, if you could.
Disclosure, and so the disclosure is a foregone conclusion. First, the password disclosure is not incriminating. A sequence of characters like 1, 2, 3, ABC does not generate leads for the government and does not form part of the government's case, nor does it form a link in the chain of evidence just because it permits the government to search the cell phone.
Counsel, is it your argument that the government can ask for and compel production of any password for any device that it has a search warrant to search?
No, Your Honor. Our argument is that the government needs to know all of the incidental disclosures as well. So the incidental disclosures are that the password exists, that the petitioner knows the password, and that the password is the right password. And in this case, all of those incidental disclosures are known to the government. That's on page 26 of the joint appendix, where the lower court found that petitioner is the only person who knows the password. In some cases, the government won't know all of those incidental disclosures, and those incidental disclosures may be incriminating. But in this case, on these facts, the government knows the incidental disclosures. And so the only potential argument that petitioner has for why this is incriminating is because it leads to evidence. But that language in Castigar requires more than but-for causal relationships between disclosure and evidence. It's not enough that the password lets the government search because the warrant is what allows the government to discover the evidence. The government here made a showing of probable cause and particularity in front of a neutral and detached magistrate and is shouldering the entire load. And so we think that in order to best effectuate the values of the Fifth Amendment, compelled password disclosure should not be considered incriminating where the government knows all of the incidental disclosures. And we think that
one of the questions, though, counsel, is what is it that the government must know? And one proposal is that if the person has an iPhone and a computer and they are password protected, then that person knows the password. And upon disclosing it, it will open up these devices. And the argument is, well, the government knows precisely what it's looking for. And you suggest that we need not worry that the government would, as it were, search for other things. And on the way to the hypothetical where the illegal drugs are in the basement, they see some other things that indicate criminal activity. Is your argument, because you cite Hemsley, is that they could not use that information to bring any type of criminal prosecution unless they had independent evidence not obtained in the process of searching these devices?
Your Honor, if the evidence discovered on the phone is within the scope of the warrant, then we don't think that there's any problem. And if the evidence that's discovered is not—
So the main problem here is a Fourth Amendment issue of particularity, not a Fifth Amendment issue of privilege?
Precisely, Your Honor. That's our contention, that the Fourth Amendment protects petitioners' privacy interests and that the Fifth Amendment protects the fair individual state balance. The Fifth Amendment prevents a person from being exposed to the coercive instrumentalities of the state in order to extort self-incriminating testimony, but it does not check the government's law enforcement powers except in those circumstances. And we think that the animating values in the relevant cases show that compelled password disclosure does not put petitioner in a position that is improper or constitutionally problematic. And we think that—
What is your view on the question that Justice Rogers raises? I mean, think of the vast amount of material, vast. A person's whole life, 90%, is in that little machine, and the password gives the policeman access to all that. Now, much more than everything that's in a house when you have a password to search the chair. much more than that. So what does the Constitution have to say about that? Does it require, whether fourth or fifth, in your opinion, perhaps it should be searched while the magistrate's in the room? Perhaps it's only the magistrate who should search it. Perhaps you should require, I don't know what. Maybe it's the Fourth Amendment, but if some of that other material is going to be, incriminating, oh, then there's a Fifth Amendment issue, because that incriminating material is not within the warrant. So what is your opinion about what the Constitution has to say about that? How should we apply?
Your Honor, we think that the Fourth Amendment, as I said, addresses nearly all of these concerns, because the particularity requirement in the warrant will prevent the government from engaging in
so should we then send this case back and say, look, this is in fact a Fourth Amendment case, and we think that the petitioner here should have an opportunity to amend the complaint so that many of these issues about the password can be raised under the Fourth Amendment. Would you recommend our doing that? Because you've heard several arguments that are disturbing in respect to allowing a password to get a hold of as much as it get a hold of the police.
Your Honor, no, that's not what we would recommend, because, well, first, we don't have the warrant here. All we have on page 26 of the joint appendix is the Superior Court's order recognizing that a warrant did issue. So it's impossible for us to evaluate what the scope of the warrant is. But nevertheless, in Ornelas, this court said that probable cause determinations by magistrates are reviewed de novo, but with great deference to the magistrate. And so I think that even if this court were to consider a Fourth Amendment issue, it wouldn't be proper to remand the case for petitioner to amend her complaint. There's simply no evidence that the warrant here exceeds the government's constitutional
I understand
rights.
your answer, counsel, but in a way, I take the spirit of Justice Breyer's question to be somewhat broader, really, which goes to, as we weigh how to interpret the Fifth Amendment in this context, there's this question about what happens when the government has the password and has the ability, as the U.S. Supreme Court said in Riley versus California, to effectively look inside anyone's life from beginning to end almost. And in a situation like that, as you know, like the framework for criminal procedure that we have is one that allows law enforcement to make use of some of the information that they stumble upon in the course of that search. So how should those considerations play a role in our thinking? Or should we just not only assume that everyone's acting in good faith, but ignore the rest of the interest in privacy that the petitioner would have in a situation where other sorts of activity, including illicit activity, might be uncovered in a search of a device?
Your Honor, although the technology here is new, this is an old problem and one that the court has confronted again and again. And in Fisher, this court said that the Fifth Amendment should not be made to serve as a tool for privacy interests, that's not the purpose that the Fifth Amendment serves. And again, in Balsas, Justice Souter, writing for the court, said that the privacy interests that Justice Goldberg and Murphy said were so important have fallen by the wayside, and that really what we're looking at here is whether the equilibrium between the individual and the state is being maintained. The Fifth Amendment is about whether the state is applying coercion to an individual in an improper way, not whether the privacy interests of the individual are being properly protected. And I take your point that it seems like there's a privacy issue here, but I would respectfully say that Riley answers the question to a large extent, that the government can't search incident to arrest without a warrant, but once they have the warrant, they can go and look within the scope of the warrant.
That's a fair answer, counsel. Since you mentioned coercion, I can't help but think a little bit about the case of Rochin v. California. Obviously, that's different. So we're talking about a case involving stomach pumping to obtain physical evidence that a defendant had swallowed, an arrestee had swallowed. But say a bit more about what exactly the government would do to compel production of the password, and does that not enter into our analysis?
Well, Your Honor, of course, the government can't torture a petitioner to make her say her password.
Thank you. I appreciate your clarifying that.
And petitioner is correct that this would put her in a cruel trilemma because she would have a choice to either lie, to say the password, or to remain silent. But our contention is that the cruel trilemma is not, as I said, the animating value here, that the cruel trilemma is not adequately serving the balance between the state and the individual. And moreover, as Justice Scalia said in Brogan, that the cruel trilemma primarily helps protect guilty people and guilty people without compunctions of lying. And the state puts people in the cruel trilemma all of the time when criminal punishments aren't at stake. For example, in Ward, a civil penalty can be very severe and a person can be put into the cruel trilemma in that scenario as well. So the kind of coercion that's applied—
You said on several occasions, the balance. What is the defendant's or the suspect's interest that is being balanced? How would you define that?
Your Honor, the interest is in being shielded from state coercion to compel self-incriminating testimony. And
by coercion, you're saying there are limits, but I'm not clear what the limits are, because there's a way to read Fisher that's very distinguishable from what the court's concern was in a lot of its previous cases interpreting the privilege against self-incrimination. And indeed, going so far as to say, in some cases, criminal prosecutions will not proceed because of the assertion of the privilege. And that's the balance that was intended. So now the question is, because we're in this new age, arguably, although you argue this is an old issue that the courts have addressed, and under the old circumstances, the courts were pretty clear about what self-incrimination meant. And now we're into sort of this sophisticated area, even though I am compelled to tell you the password. Somehow that's not testimony, that's not incriminating, even though it unlocks the door that leads to my criminal prosecution and the government obtains evidence to meet its burden of proof. So we're redefining the nature of the privilege. And I saw Fisher as dealing with a different situation. I mean, it's not the defendant, it's not his papers, they're not in his possession, their business records, et cetera. They were pre-existing. And there's some concern there too, since the accountant is acting as his agent. But aren't you just limiting the balance here in favor of facilitating law enforcement and abandoning the court's concern about the zone of privacy and privilege that the Fifth Amendment protected as distinct from the Fourth Amendment?
No, Your Honor. And I think there are three important things to keep in mind here. The first is that in Doe 2, the court said that Fisher was applying basic Fifth Amendment principles and that it wasn't narrowly confined to the factual context there. And second, relatedly, in Doe 2, the court allowed the state to compel a person to sign a generic consent authorization form for banks to release records in response to a subpoena. And we think that in this case, petitioner is being asked to do nothing more, to simply authorize a legitimate exercise of government authority. But
the consent form in Doe 2, the court emphasized, was worded in such a way that it was not incriminating in the normal sense of the word.
Your Honor, that, to my understanding, was to prevent the government from getting those incidental disclosures that it didn't already have, that the person in that case had those bank accounts, had control over them. The government couldn't demonstrate that to the standard of that the court in Fisher required. And here the government has met that burden, and the lower court has found that. And so we think that under Fisher, this should be an easy case. The only hard part of the case for us, we think, is the fact that petitioner is being asked to say something. That is a tough aspect.
That is the hard part.
It is the hard part of the case for us, but we think that this court has not drawn such a hard line between oral and written statements and gestures or actions. In Doe 2, the court said very nearly all oral and written statements will be testimonial, but that leaves room for some to not rise to that standard. And the court in that case said that in cases like Wade and Gilbert, the voice and handwriting exemplar cases, that the person was being asked to do something, to write something down, to say something.
Well, I mean, no testimony there, so. I mean, the court has limited those cases, hasn't it? And you're posing an extension to Fisher that even though Doe has that general language in it, the court doesn't seem to have acted on that to date.
Well, Your Honor, I think that Doe already affected that extension, and it wasn't an extension that the court chose to take up in Hybel, but it was a possibility on the table. The court first said that they wouldn't resolve the issue on the grounds of whether being compelled to say your name was testimonial, but the court also didn't affirmatively say that in all cases saying one's name would be testimonial. And we think here that being asked to state your password is very similar to being asked to sign that consent authorization form. It's what the court in Doe 2 said, an acknowledgement of what the court is asking the person to do. The person is being asked to acknowledge that they're signing a consent form. They're being asked to acknowledge that this is their password, just like they're being asked to acknowledge this is their handwriting. This is their voice. When you're producing a voice exemplar or a handwriting exemplar, you're using your mind you're revealing the contents of your mind. You're deciding whether or not to speak in your regular accent, to speak in the way that you usually do. And the court said that that wasn't sufficiently testimonial. That's how Fisher read those cases. And so we think similarly in this case, being asked to say your password is not sufficiently testimonial to warrant the application of the Fifth Amendment privilege. And if there are no further questions, I would respectfully ask this court to affirm the lower court's judgment. Thank you.
Thank you, counsel. Now, next is there's a rebuttal. Fine, counsel, please.
Thank you, Mr. Chief Justice, and may it please the court. I'd like to begin by making a point about Doe 2. In Doe 2, the court made very clear that the suspect didn't say anything by virtue of the way the authorization form was written. So it's incredibly different from the case here. The appropriate analogy here, if Doe 2 were to be the governing law, would be to say, have Ms. Tanner say, if I have any encrypted devices out there, the state may have access to them. That would be the equivalent of what was forced to be signed in Doe 2. And the state could certainly force Mrs. Tanner to sign something like that. What it can't do is what it's asking her to do here, which we want to make clear is two things. First, to say, this is my password. That's explicitly testimonial. And the court has never applied the foregone conclusion exception to strip explicit testimony of that protected value. But we think importantly, we want to correct what we think the state uses as a mistaken analogy. The foregone conclusion exception applies to the implicit testimony in the act of production. The act of production here is turning over the documents. And the implicit testimony is that they exist, that Ms. Tanner possesses them, and that they're authentic. And a simple example shows why that's the act of production. If I hand my encrypted phone to my brother, he doesn't, and without the password, he doesn't have anything. He has the equivalent of a paperweight. But as soon as I disclose the password to him, as soon as I say, this is my password, he has access and complete dominion over everything on the phone. So no one would think you've just given the password. You've given everything on the phone and therefore implicitly testified everything that went along with producing that material. The final point I'd like to make is just a note on the severability question. The appropriate remedy here for severability would be for this court to send the statute back to Ames, for Ames to pass judgment on what the statute here actually means. In addition to that, the state cited Reno v. ACLU, but that case involved the Communications Decency Act. That was a federal statute, which was different here because it's a state statute at issue. For all three of those reasons, Your Honor, we think it's important that for those reasons and the other reasons that my co-counsel and I discussed earlier, we'd ask this court to reverse the decision below. And if there are no other questions, that's what we'd ask you to do.
Thank you, counsel. Thank you. Do we applaud? Can you applaud? I thought it was very good.
All rise. The judges will now leave to deliberate.
Well, I think that the argument was a very good argument on the part of the counsel. You did get the experience that you might have arguing through several different kinds of courts and very tough questions. And I think people responded well, and the briefs were extremely good. It was very difficult for us to make a decision. It was in this case. There have been other instances where it wasn't, but not this one. And so I will not keep you in suspense. The best oralist, after discussion, we decided was Travis Fife. The best brief, we decided was the petitioners. And the overall best team, we decided was the respondent. And it could have been the other way around, I promise you, but very, very good for all of you. And there we are.
Congratulations.
Yeah.
Well done.
Yes. I mean, not easy. Very difficult case.
Mm-hmm.
Very good issues. Very well prepared. And well argued. And you have to meet the questions of the judges, who you will find probably know the case less well than you do. And you have to point it out to them without insulting them. That's not so easy. So easy.
All rise. Thank you for attending the Ames Moot Court Competition. We hope so much to join you in person next year. Thank you very much and have a lovely evening. Goodbye, everyone. Congratulations to the respondents.